Hello everyone, my name is Imran and I'm going to present the facts, the arguments and the issues in the case of Bank of India versus Govindram, Narendas Sadhwani and others, Hong Kong High Court 1982. So first of all, the facts and arguments of this case are the Bank of India initiated the suit against Govindram, Narendas Sadhwani and his wife living in Hong Kong. They had acted as guarantors of a loan of 230 million yen that the Osaka branch of the bank had provided Sarvindans Sadhwani's Limited (SJL). SJL was managed by Mr. Govindram, who owned 40% of the company, and his brother Krishan Chand Narendas Sadhwani, who owned 60% of the company. SJL had drawn bills of exchange that were supposed to have been paid by corporations in Sri Lanka and Nigeria that were run by other brothers. When the bills were dishonored, the Bank of India sought payment from Mr. Krishan Chand. However, he argued that it should pursue the Hong Kong guarantors, the Govindrams. At first, the bank did not care to sue the Govindrams because it had agreed to release them as guarantors before the bills of exchange had been drawn. But with Mr. Krishan Chand's provisional attachment and promissory offer, the bank then sued the Govindrams and at the trial, and Govindrams in turn brought the Krishan Chands at third parties. At the trial, the Govindrams argued that the proper government law was Japanese law, whereas the bank argued that either Indian or Hong Kong law should be applied. Those are the facts and arguments of the case, and the issues are whether or not Japanese law is the proper law of contract. Thank you.
Hello everyone, this is Bing, and still number is AMD3026. I represent the part of the conflict of laws. The general is that the court should apply the law of the state that has the closest and the most real connection with the dispute, as long as the expressed or inferred intention as to the proper law is absent. Review the three stage or sub-rule test defined in Dicey and Morris, the conflict of laws. For this case, we will doing the sub-rule test to determine the conflict of laws. Sub-rule 1. When the intention of the parties to a contract as to the law governing the contract is expressed in words, this expressed intention in general determines the proper law of the contract. Sub-rule 2. When the intention of the parties to a contract with regard to the law governing the contract is not expressed in words, their intention is to be inferred from the terms and the nature of the contract, and from the general circumstance of the case, and such inferring intention determines the proper law of the contract. Sub-rule 3. When the intention of the parties to a contract with regard to the law governing it is not expressed and cannot be inferred from the circumstance, the contract is governed by the system of law with which the transaction has its closest and most real connection. Thank you very much.
Hi, my name is Sohel and my student ID is INT3290 and I'm going to talk about the case study which we have decided to talk on the Bank of India versus Govindram, and there's a three sub rule apply in that review of three stage or sub rule test define Dicey and Morris the conflict of laws. The first one I'm going to talk about that in review the guarantee contract there was no express intention in regards to the law, the governing contract. The second sub-rule applied to that one is the plaintiff study, the claims contract, and the contains elements of the study. Second one is convenience. The third one is referral to the currency but referred into the yen. They took the money in the yen in the currency was in yen, not in the Indian currency. So SGL is joined Indian company in Japan. They was running company in Japan. So they took the borrow the money from the Bank of India in yen. And another sub rule applied to C3 is the great weight of the place of performance of Japan. 2 out of 4 guarantors resides in Japan. Third one is negotiation in Japan. The fourth one is the guarantee form part of SGL in Japan, and the principal sum was 100 yen stamp. All guarantors had assets in Japan. So whatever the guarantors are in there, all the guarantors they have assets in Japan. So they are all liable for that. Whatever this happened. That's all. Thank you.
Hello, my name is Sukhraj, and in case of Bank of India versus Gobindram Narendas Sadhwani, the final decision of court comes up to be that yes, the Japanese law of contract is right because of the third stage, and the third stage is the law which the transaction has its closest and most real connection will be applied. Moreover, the Japanese law excuses the Gobindram from liability, and the final decision made by court was the plaintiff case was dismissed. Thank you.
Hello dear Elena, my name is Jyoti. My student ID is AZZ3039, and I'm going to talk about the decision that court applied on the case study of the Bank of India and the Govindram, Sadhwani and others. So in deciding the legal systems, the court usually give weight to the jurisdiction of the place of performance. Even though so many people think that the law applied, the Japanese law applied on the case study was a proper law, but my opinion on this is that the Indian law should have been applied because the guarantors were Indian, and furthermore the yen was used as a transaction, as a convenience of the transaction, but the currency was, the loan was originally issued in Indian rupees. And even in India, the Bank of India's main branch is located in India, and it has its own financial and governing terms to process the financial processes. So it should be according to the Indian law that should have been applied on this case study. And there are 2 discussion questions on this case study after I have given my opinion. The first one is could Hong Kong's High Court dismiss the case without addressing any proper law or the legal system? And the other one is, as the contract was made between SGL and the Bank of India's, the Osaka branch, and it was the Osaka branch that released Govindrams as guarantors. But my question is that does the branch of Bank of India's Osaka branch hold more power than the main branch of the Bank of India to make their decision? And would it be different under different legal systems and under different laws? That was all about my presentation. Thank you.